Welcome to the American Museum of Tort Law panel on litigation and advocacy to confront and survive the climate crisis. I am Pamela Gilbert, partner in the law firm of Cuneo, Gilbert and LaDuca based in Washington, D.C. I'm also a consumer advocate who specializes in protecting access to the courts. I'm joined today by an exceptional group of experts who will talk about ongoing litigation to hold the oil and gas industry accountable for their decades of deception that led to the climate crisis. Much like the tobacco industry, fossil fuel companies engaged in an orchestrated campaign to deny climate science and foster doubt and uncertainty to prevent policymakers from addressing the environmental catastrophe that the company's own scientists were predicting. Our panelists will explain to you what the companies did and how communities are fighting back in the courts to hold them accountable. So I'm going to just start off by introducing you to my fellow panelists. Alyssa Joel is an environmental and human rights lawyer with a deep understanding of pressing climate issues and the tools needed to address them. She currently serves as legal director with the Center for Climate Integrity, where she is supporting efforts to hold fossil fuel companies and other climate polluters accountable for the damages they have caused. Alyssa previously worked as an independent consultant, working across disciplines to develop strategic and innovative solutions to the climate crisis through a rights and justice lens. Alyssa also worked as a senior attorney at the Center for International Environmental Law, where she advocated on behalf of peoples and communities most vulnerable but least responsible for climate change, and developed legal strategies to hold state and corporate actors accountable for their contributions to the climate crisis. Vic Scher is a founding partner in Scher Edling LLP based in San Francisco. He represents public agencies as plaintiffs in high-impact environmental lawsuits. Vic is the lead outside lawyer for 16 public agencies in climate change damages cases against the fossil fuel industry brought by 3 states, the District of Columbia, and 12 cities and counties. For much of the last 2 decades, Vic's practice focused on representing public water suppliers and other public agencies in lawsuits against the manufacturers of toxic chemicals polluting drinking water sources. His non-climate docket continues in these kinds of cases. In 2009, Vic served as New York City's lead trial counsel in City of New York versus ExxonMobil, a federal jury trial over MTBE contamination in Queens that resulted in a verdict for the city of $104.7 million. Before entering private practice in 1998, Vic practiced with the public interest law firm Earth Justice from 1986 until 1997, including as its president from 1994 to 1997. Karen Sokol is a professor of law at Loyola University New Orleans College of Law. Her research and teaching interests include climate law and policy, corporate disinformation and accountability, international law, and tort law. Her current scholarship focuses on climate litigation, fossil fuel industry disinformation, and on the need to center the Global South in international climate policy. She graduated from Yale Law School and is currently a member scholar of the Center for Progressive Reform and a researcher at the Climate Accountability Working Group of the Climate Social Science Network. So quite an illustrious and expert panel. And we're going to start off with Alyssa Joel, who's going to talk about the industry's campaign of climate deception.
So I'm here today to talk about the industry's ongoing history of climate deception and denial. And to really introduce this story, it's a simple story. It really involves one in which the major oil and gas companies knew as early as the 1950s and no later than the 1960s that the harms associated with their products would lead to climate change. And by the 1980s, they were predicting, in their own words, globally catastrophic effects. Yet instead of warning the public or leading the transition to cleaner energy sources, the fossil fuel industry chose to protect their profits with a massive coordinated campaign to deny, doubt, and delay climate action. We know this story thanks to hundreds of internal industry documents uncovered by journalists and researchers from across the country and the world. And today I'm going to share just some of the highlights of these documents, both historically and bringing to the modern present day, the history of deception. So as I mentioned, big oil knew as early as the 1950s and no later than 1960s about the causes and consequences of climate change. In 1968, the industry's largest trade association, the American Petroleum Institute, commissioned this report from the Stanford Research Institute that linked increasing CO2 to the burning of fossil fuels. And while the report acknowledged that they didn't have all of the answers, it concluded there seems to be no doubt that the potential damage to our environment could be severe. In the late 1970s and early 1980s, Exxon and other fossil fuel companies were on the cutting edge of climate science. They were running innovative climate research programs, oftentimes in partnership with government and academic scientists, to better understand this threat to humanity. This slide in particular demonstrates an excerpt of a memo, a 1978 memo from Exxon scientist James Black to the Exxon Management Committee, describing his findings that CO2 concentrations are increasing, that increase is attributable to fossil fuels, and that increased CO2 would in fact cause warming. Black noted at this time that time was of the essence to address this problem, giving the company a 5 to 10 year window to take urgent action. In 1979, another Exxon scientist, Farrell, summarized findings of an internal Exxon study that proved to be remarkably accurate. In this memo, they predicted that we would reach 400 ppm in 2010, when in actuality, we reached it in 2013. Farrell also noted that restrictions on the use of fossil fuels would likely need to be limited, or would likely be needed to limit CO2 concentrations below 400 ppm. Many of these memos concluded that more research was needed, but according to Exxon scientist Ed Garvey, the issue wasn't whether or not climate change would be a problem. The issue was how fast and how bad it would be. By the 1980s, the answer was pretty clear. At least 3 internal industry assessments concluded that climate change could lead to catastrophic effects. In 1980, an API, again, American Petroleum Institute consultant, presented to the group's CO2 and Climate Task Force and predicted that based on present trends in fossil fuel use, the world would see globally catastrophic effects by the year 2067. Then in 1981, Exxon scientist Roger Cohen wrote a memo stating, it is distinctly possible that the corporate planning department scenario will later produce effects which will indeed be catastrophic, at least for a substantial fraction of the Earth's population. And again, in 1982, an internal Exxon report noted several potentially catastrophic effects, including the melting of the Antarctic ice sheet that would lead to sea level rise that would flood Florida and Washington, D.C. To be clear, these predictions were not random guesses out of left field. It was well understood, and there was a general consensus on climate change at this time. The industry research was incredibly advanced and stunningly accurate. And in 1982, in fact, Exxon accurately predicted the level of CO2 and temperature rise we saw in 2019. That same year, an Exxon memo concluded that the company was in agreement with the scientific consensus on climate change. So there really was no doubt at this moment in time that there was a clear understanding of the potential threat, of the severity and the harm associated with climate change. But in the mid to late 1980s, despite this knowledge and the understanding that their own internal scientists had, the tables turned. Exxon and other fossil fuel companies stopped funding climate research programs and instead launched campaigns to discredit climate science and delay actions perceived as contrary to their business interests. They developed PR strategies that were contradictory to their knowledge and scientific insights. They engaged in public communications campaigns to promote doubt and downplay the threats of climate change. And they funded individuals, organizations, and research that discredited the growing body of publicly available climate science. And a few of these documents really help to illustrate the doubt and uncertainty and the position that Exxon, the American Petroleum Institute, and others were taking at this time. This document in particular was an internal Exxon memo acknowledging the realities of climate change, but then stating its position to emphasize uncertainty despite their own scientists' internal agreement. Then in 1996, the American Petroleum Institute coordinated public messaging at this moment in time and prior. And this 1996 book illustrates that there was not conclusive or even strongly suggestive evidence that humans were affecting the climate. Companies and trade associations came together to form the Global Climate Coalition, which was singularly focused on defeating climate policy. This document in particular shows that the group maintained that warming was part of a natural trend, and there was no evidence that greenhouse gas emissions would cause significant climatic impacts, despite all of the evidence these companies had to the contrary. And then I think one of the most compelling documents that we have, which is oftentimes referred to as the Victory Memo, is this 1998 document that was developed by the API's Global Science Communications team, which consisted of representatives from fossil fuel companies, PR firms, third-party front groups, and other industry executives. This was developed in the aftermath of the adoption of the Kyoto Protocol, when they launched a communication strategy to influence Congress and effectively block ratification, which they were successful in doing. And as you can see, victory will be achieved when average citizens understand uncertainties in climate science. This was very much their mission, and they undertook it with remarkable precision. As the years progressed, moving into the late 1990s, early 2000s, companies began to shift from the outright denial that we had seen in the 80s and 90s to one of duplicity, one which we often refer to as greenwashing. They're portraying themselves as good faith partners committed to taking action and being part of the climate solution, but that's far from the case. And I just wanted to offer a few examples of early greenwashing to illustrate this. Shell, more than 20 years ago, said it was committed to taking immediate climate action, exceeding the Kyoto targets, and making real investments in renewables. Shortly after, in the year 2000, BP spent $200 million to rebrand itself as Beyond Petroleum, thinking of itself not as a fossil fuel company, but as an energy company that was helping to assist with the transition. Even Chevron and Exxon began running advertisements about their commitment to renewables. And all of this continues to this day. I wanted to show a few examples of the types of images that you might be seeing on billboards or advertisements in your day-to-day life. These are just a sampling to show. But as these companies portray themselves as leaders in climate change, I think it's fair to say that there hasn't been any real meaningful action. These companies have worked very hard to boost their public image while actually doing very little to clean up their operations and shift to renewable energy. According to an analysis by CDP, oil industry investments in low carbon were just 0.68% of capital expenditure in 2010 through 2017 and 1.3% in 2018. So you can see that these investments are actually quite nominal. And yet they continue to fund misleading information. Exxon, Shell, BP, Chevron, and Total collectively spent $1 billion on misleading climate-related branding and lobbying from 2016 to 2019. And all of this at the same time, they are intending to double down on fossil fuel production. As you can see, they plan to increase production dramatically between 2018 and 2030. This deception, as I've mentioned, started back in the knowledge that they had of the causes and consequences of climate change date back to the 1950s and 1960s. And the campaigns of deception and denial started in the mid to late 80s, but they continue to this day, and they've just taken another form. And with that, I'm going to turn over the presentation to my colleague Vic Scher to discuss the legal actions that are well underway to hold the fossil fuel industry accountable.
Thanks, Alyssa. Thanks to the Tort Museum and to my co-panelists. It's really a pleasure and an honor to be here. I'd like to put the current set of lawsuits in a little bit of an historical context and then turn to what's going on in them and see if we can derive some themes from that. Over the last decade and a half, there have been what I now think of as 3 waves of climate change related tort lawsuits. The first was with the AEP v. Connecticut case that went to the Supreme Court, and the Kivalina, native village of Kivalina case that went to the Ninth Circuit. Those were both cases that focused on the emissions of the defendants and sought court orders either seeking to regulate those emissions to address climate change or to achieve those regulations plus damages in the case of Kivalina. And the court said that those kinds of emissions were subject to the Clean Air Act, which had displaced the federal common law under which the cases were brought, and that the cases could not proceed under federal common law. The courts left open the issue of what state law remedies might be available to injured plaintiffs. The second wave of cases is actually just one, and it's the City of New York case, which is very recent, was filed contemporaneously with the third wave, but thematically and legally is quite different. In New York City, the city claimed that that climate change was a public nuisance for which the city was entitled to damages from the defendants, but they limited their claim to a focus on the lawful and legal conduct of producing and selling the products. And the court said, in a decision that has been both criticized by many commentators and embraced by the industry, that in effect that meant that there was a strict liability that would attach, that there was nothing that the defendants could do to avoid liability other than to cease producing and selling their products, and that constituted an impermissible regulation of interstate emissions and pollution. So that case failed in April of this year, 2021. The cases that I'm involved in, there are now 21 cases. They include cases brought by 6 states and the District of Columbia, as well as 15 cities and counties around the country. I'm not involved in all of them. I am involved in most of them. And they are based expressly, thematically, and legally on the course of deceptive conduct that Alyssa just touched on the highlights of a few minutes ago. There are 4 cases in the current group that are focused on statutory consumer protection acts that focus exclusively on false and misleading statements made in the marketplace and seek to obtain remedies, generally statutory penalties associated with them. And the Massachusetts, Connecticut, Vermont, and DC are exclusively based on that kind of a claim. There are 3 cases, not necessarily those, that are against Exxon only. And the other cases are all either tort claims or tort plus Consumer Protection Act type claims. And there are some that involve both. For instance, Delaware's and Minnesota's and Baltimore's cases all involve a combination of tort laws and tort remedies rather, and Consumer Protection Act claims. The tort law claims vary, as you might expect, because tort law varies from state to state. Some of them, in fact, many of them, but not all of them, involve claims for public nuisance. But they are all based thematically on the course of deceptive conduct that Alyssa laid out. Now, these tort cases are the ones that I want to focus on today. These are not cases to solve climate change or set legislative or regulatory policy. They are backward looking, not forward looking, and they are about surviving climate change in the sense that they seek to recover for their communities and states the resources necessary to adapt and mitigate to climate change impacts caused by the defendant's deception. And I have to tell you that as a trial lawyer, there are three things that I look at about what makes a good case. The first is there robust science? So can we tie in this context, in a scientifically robust manner, the relationship between fossil fuel combustion emissions on the one hand and climate change related impacts on the other? The answer to that is overwhelmingly yes. It's not new, it's not cutting edge, it's not wacko science. It is middle of the road mainstream science. We can, as a matter of fact, if we know a volume of carbon or CO2 equivalent emissions, calculate the temperature response in the atmosphere, as well as things like sea level rise and other climate related impacts. So very strong science. Second is, can we link the impacts to the defendant's behavior? In this case, or this set of cases, their deception. So the causal chain, and this is how the Fourth Circuit Court of Appeals described it in the Baltimore case last year. Baltimore does not merely allege that defendants contributed to climate change and its attendant harms by producing and selling fossil fuel products. It is the concealment and misrepresentation of the product's known dangers and simultaneous promotion of their unrestrained use that allegedly drove consumption and thus greenhouse gas pollution and thus climate change. It's our burden, that is, it's the plaintiff's burden to establish that the deception mattered and that it made a difference in the world and contributed to the plaintiff's injuries. If we fail to show either that there was any deception or that the deception didn't make any difference, then these cases lose. But within that context, these are middle of the road, mainstream, well-established tort claims, illustrated by cases like the lead paint decision out of California and cases involving MTBE and other pollutants and similar things. And then the third element that a trial lawyer looks at, is there a good culpability story? And Alyssa laid out the elements of it, and I will tell you that we believe it is a very strong story that we're eager to get in front of a jury. One point to make is that the period of knowledge and deception that Alyssa laid out corresponds directly with what scientists call the post-World War II Great Acceleration, during which the vast majority of all of the industrial base, that is coal, oil, and gas emissions, have occurred in history. In fact, more than half of all those industrial emissions have occurred since the late 1980s and more than 3/4 since the 1960s. So we're looking at a problem that is of recent development and during a period of industry knowledge and culpability. The big fight so far has been in the cases has been over whether they can proceed in state court or federal, or must proceed in federal court. They were all filed in state court. They were all removed. We are currently 13-0 on district court orders of remand and 5-0 on Court of Appeals affirmances, although 4 of those were based exclusively on an issue of federal officer removal jurisdiction. And I will not bore everybody except law professors and those of us who practice in this field with the details of all that. But there are 4 cases in which there are no stays, and remand has sent the cases back to state court, and they are in theory free to move forward. In Rhode Island, Baltimore, and Boulder, the cases are back in state court, have been briefed on the preliminary rounds of motions to throw the defendants' efforts to throw the cases out. But the judges have either formally or informally stayed the cases pending various other developments. For example, one of the issues is whether there is personal jurisdiction over these companies in these states. And in Rhode Island, at least, we're waiting on an opinion on a related issue from the Rhode Island State Supreme Court. The case to watch, I think most carefully at this point, is the City and County of Honolulu's case, which was remanded, not stayed by the federal courts, not stayed by Judge Crabtree in the state court. The motions were argued in late August and early September, and we're awaiting the decision from him. And I'm now going to turn this over to Karen Sokol, who's going to talk about the role and importance of state courts in these cases.
I'd also like to thank the American Tort Museum for hosting this event and for inviting me to be on this panel. And I'm grateful to my co-panelists for serving with me and having this discussion. So as Vic said, I'd like first to talk about why the sort of cases that Vic is working on that he described in the third wave are particularly well suited to, from a broader legal perspective, to providing accountability and some modicum of redress for the sort of systematic deceptive marketing that illicit a tale that the fossil fuel industry has been undertaking for decades now. And second, I'm going to talk a bit about why I think these state cases are particularly important now. So as to the first point, why from a broader legal perspective are these cases well suited to the allegations and the complaints? In the US constitutional structure, states have always played an essential role in providing their residents with basic human security in the form of public health and safety protections. And indeed, in numerous cases, the US Supreme Court has emphasized the importance of this role of states. It calls health and safety, quote, a traditional area of state concern for states. And states, in carrying out this role, beginning in the 1960s, as companies were increasingly using mass marketing to sell unsafe products, states started realizing the extent to which these campaigns presented public health and safety threats. And states were increasingly called upon to apply state laws that provided protections and accountability for deceptive marketing campaigns. The two primary types of state laws that serve this purpose and that were invoked in state courts are the ones that the current wave of state cases against fossil fuel industry defendants are relying on. So namely, state tort law and state consumer protection statutes. And now I'm going to say a bit more about both types of law and states' role in our system in applying them. So starting first with state tort law. State tort law has always been an important legal mechanism in this country for holding private actors accountable for misconduct and providing some compensation to those harmed by that misconduct. It's become increasingly important in serving this role, though, since the mid-20th centuries, as corporate actors amass greater economic and political power, coupled with, importantly, significant control over information that comes with very sophisticated and often deceptive marketing campaigns. And in the 1960s, in response to widespread harms caused by businesses' mass marketing of unsafe products, coupled with their use and supported by misleading marketing strategies, state courts began drawing on existing, very long-standing state tort law principles to provide relief to the injured, as well as accountability to the public at large. And around the same time in the 60s, there's an uptake. State legislators began enacting more consumer protection statutes that impose civil penalties for deceptive marketing. And this is all in recognition that deceptive marketing not only deprives state residents of their right to make informed decisions about what they purchased, but often also presented them with significant public health and safety threats. So, although these current United States state climate cases, they're the first, a new wave in a sense, to hold fossil fuel industry actors to account in state court for disinformation regarding climate science and the catastrophic public health dangers of fossil fuel products. They're certainly not the first state cases to hold industry, or that can hold industry, to account for public health and safety threats and harms caused by deceptive marketing campaigns. So in this latter sense, despite the industry's claim to the contrary, state tort and statutory claims are well suited to allegations of deceptive marketing that are detailed, greatly detailed, in the complaints in these cases, and that the state courts with experience applying their state laws are the most appropriate venue for these to be adjudicated. Additionally, it also makes sense that these cases are being brought now and that they're on the rise, because the climate crisis presents the greatest public health and safety threat that we've ever faced. So though climate harms, as well as the industry's disinformation campaign, are of a magnitude far beyond what state law, state tort law, state consumer protection statutes, and indeed any aspect of law has ever dealt with, the plaintiff's allegations regarding the fossil fuel industry defendants' contributions to those harms through systematic disinformation campaigns are the sort of corporate malfeasance that state laws and thus state courts have been addressing for decades. That is, it's the magnitude and the severity rather than the type of misconduct alleged that's distinctive about these cases. And indeed, because of that magnitude, because of the pervasiveness and the astoundingly tragic success of the industry's disinformation campaign, I believe these cases, if allowed to proceed, may prove to be the most important example of this function of longstanding state deceptive marketing laws to date. They are, in fact, an important example of our constitutional system of divided governmental powers at work. Well, they are, I'll say, if the defendant's concerted effort to keep these cases out of state court doesn't succeed. Which brings me to my second point about why I think these cases are particularly important now. And relatedly, why the industry is fighting so hard to keep them out of state court. The fossil fuel industry's deceptive marketing tactics are an important part of this country's political and cultural history that can inform our decisions about how best to respond to the climate emergency. And this is particularly important now, as Alyssa detailed, as the industry's disinformation continues and grows even more insidious and sophisticated as calls for climate action grow louder. And the state civil discovery and trial system is a powerful tool to expose hidden information and to bring into sharp relief the harms caused by misconduct. And the fossil fuel industry knows that. And I'm just going to show my screen to include a bit of language here. So in a recent article, I characterize the fossil fuel industry's business strategy as one of disinformation plus path dependence. And this dual-pronged strategy involves aggressively marketing products to create fossil fuel dependent societies, coupled with massive and systematic disinformation campaigns to counter and obscure the catastrophic dangers of those products. Today, the industry's disinformation campaign has shifted gears. So this strategy is framed at a high level because it easily morphs in response to a given information landscape. So today, in response to increasing revelations about climate dangers of fossil fuel production and use, the industry has shifted gears from overt denial of science establishing fossil fuels are driving climate disruption to denying the science establishing the need for a dramatic and rapid transition away from fossil fuels, which is key to their ability to maintain fossil fuel dependence and thus to ensure that their production assets that they have planned are not stranded. State courts, as all courts, apply laws to the evidence brought before them. And in his opinion, holding that Rhode Island's case, one of the cases in that group of third wave cases, belonged in state court and not federal court, Judge William Smith, the District Court of Rhode Island, he eloquently summarized how the complaints lay out evidence of this disinformation plus path-dependent strategy, and making clear why it's necessary to evaluate these allegations through the lens of deceptive marketing laws of the sorts that state courts have long been adjudicating. Of course, the nature of evidence that plaintiffs bring to courts changes both as facts that plaintiffs experience evolve over time and as we learn more facts. And in our current and future reality of a disrupted climate, and increasing revelations by researchers and journalists about the fossil fuel industry's deception, it's vital that we come to understand the full nature of any wrongful conduct that got us here, and that we forge accountability for that conduct. And invoking state laws and state courts isn't the only way to achieve that, but it's a key way. It's a key way among our existing laws and institutions of government. And it is by far not the only response we need, but it's one of the responses we need now. And I'll close by turning it over to Pamela to talk about potential responses by Congress that may serve to complement efforts to hold the industry accountable in state courts.
Thank you, Karen and Vic and Alyssa. I learned a lot listening just now. That was awesome. So yeah, so I'm going to round out the discussion today by talking about how Congress fits into the effort to hold polluters accountable, and that's by proactively protecting access to the courts, as has been described, and investigating industry misconduct. So there is a playbook that's used by major industries that are facing litigation over harms caused by their products or their conduct to try to prevent the cases from ever reaching a courtroom. That is their goal. And what they do is they go to Congress and they request or they ask for a liability shield. And the more dangerous and widespread their harm, the more serious their campaign for immunity. So for example, the tobacco industry initially sought a liability waiver in exchange for federal regulation. They did not get that. The asbestos industry has been trying for immunity for decades. And unfortunately, federal legislation that passed in 2005, shielding the gun industry from lawsuits due to gun violence, does continue to block justice for families across the country to this day. Well, the oil and gas industry is no exception. So in 2017, when the Climate Leadership Council, which is a group backed by major fossil fuel and other multinational corporations, when they first debuted their Baker-Schultz carbon price proposal, which is named after Republican luminaries James Baker and George Shultz, the proposal included immunity from the climate change lawsuits you've been hearing about. About 2 years later, CLC quietly dropped the immunity provision from their platform because environmental groups were so outraged and expressed their strong opposition. But the cat was out of the bag about what the industry was seeking. Now, then in March 2020, in the early stages of COVID relief discussions, a proposal was floated in the Senate that would have provided the entire energy sector with complete immunity for any action taken to respond to the COVID emergency, unless you could prove that the company intended to inflict harm, which is essentially impossible to prove. So unfortunately, 60 members of Congress signed a letter that was led by Congressman Jamie Raskin opposing any kind of liability shield for the fossil fuel industry, and that proposal died. But we know the oil companies want immunity, and we know they will continue to lobby for it whenever Congress considers legislation to address climate change. While it is the case that Congress should really never provide legal immunity for wrongdoing to an entire industry, providing a liability shield for polluters in climate change legislation is a particularly terrible idea. As has been discussed, legislation to address climate change going forward is completely unrelated to lawsuits seeking to address harm that has already been done. The first is what Congress and legislative bodies are set up to do. They establish public policy going on into the future. But lawsuits seeking compensation and accountability for past injuries is what courts do. It's apples and oranges. And as Karen so well laid out, courts are uniquely suited for this task. Litigation with its extensive discovery and the adversarial process and expert testimony is an ideal system for ferreting out the facts of a case, applying the law, and deciding liability and damages. This has been the role of the civil court system for centuries, to determine fair compensation or penalties for wrongdoers to pay for harms they've caused. Climate change lawsuits are really no different. As Karen said, the crisis may be larger, but the principles are the same. And furthermore, allowing fossil fuel companies to escape accountability for their decades of deception would set a terrible precedent. If powerful industries know that they can use their political muscle in Congress to escape responsibility for wrongdoing, it will only lead to more wrongdoing, more harm, and millions left without recourse. And if the companies responsible for climate change aren't held accountable to pay for the damage they've caused, those damages don't go away. The states and communities across the country that are suing will be on the hook for billions of dollars in adaptation and recovery and mitigation costs. Or, if is likely, the communities can't afford it, they'll simply suffer the flooding and the fires and the other devastation without the resources to address the damage. Entire communities could be lost, and the responsible parties will have gotten away with it with no accountability. But it actually isn't enough to simply reject the industry's attempts to push for a liability waiver. Congress has to do more. It must proactively protect the cases by including a savings clause in climate legislation. In recent years, Supreme Court opinions have increasingly interpreted regulatory statutes as preempting damages lawsuits, even where that was never Congress's intent. So in order to ensure that climate litigation is not blocked by legislative preemption, the climate legislation may need to include a savings clause, which is a provision that explicitly states that nothing in the bill is intended to preempt or displace lawsuits brought for damages. The savings clause could be necessary even if the legislation does not contain any language, explicit or implicit, that would preempt lawsuits. But Congress also has another role to play here. Congress has a rich history of investigating corporate abuses, leading to groundbreaking revelations and reform. Perhaps the most famous example are the tobacco hearings, in which the CEOs from Big Tobacco all swore under oath that nicotine is not addictive, despite internal industry documents proving they knew that it was. The deception uncovered by those investigative hearings facilitated the industry's landmark tobacco settlement with state attorneys general and helped lead to FDA regulation of cigarettes. And a similar effort is currently underway in Congress. It started in October of 2019 when Congressman Jamie Raskin, who serves as the chair of the Subcommittee on Civil Rights in the Oversight and Reform Committee in the House, he held a hearing to examine the fossil fuel industry's efforts to suppress the truth about climate change. And among the excellent witnesses at the hearing were a former Exxon scientist and a former Exxon consultant who testified about their early research papers in the 1980s, drawing the connection between fossil fuels and catastrophic climate change. And yet, as Alyssa laid out, while those papers were coming out and afterwards, Exxon executives spent tens of millions of dollars on public relations campaigns, sowing doubt and denial about their product's role in the coming climate crisis. As the Exxon consultant explained at the hearing, Exxon was aggressively promoting views that its own scientists knew were wrong. And then, and more recently, and we've gotten a glimpse of the ongoing deception campaign that's going on today, when an Exxon lobbyist was caught on video describing the tactics that the company is using to obfuscate and hide the company's true intentions. So on camera, very recently, he explained how the company fought science, joined shadow groups to block climate efforts, used trade groups as the whipping boy, those were his words, to advocate for policy positions that ExxonMobil did not want to be associated with publicly. And he called their support, the company's support for a carbon tax, an easy talking point because the company believes that it will actually never pass Congress. Those revelations, when they came out, precipitated a new investigation by the House Oversight and Reform Committee, led by Chair Carolyn Maloney and Environment Subcommittee Chair Ro Khanna, into the fossil fuel industry's deception. So their first hearing was held in October, and they brought the CEOs of Exxon, Chevron, Shell, and BP, as well as the American Petroleum Institute and the US Chamber of Commerce before the committee to answer questions about their decades-long climate disinformation campaign. And while the witnesses themselves offered lukewarm acknowledgements that their company's products have, quote, contributed to global warming, and that the companies want to, quote, be part of the solution, they actually had no responses to the committee members' questions about their past deception and their current greenwashing efforts. Chair Maloney was so disappointed by the CEO's obfuscations, she announced on the spot at the end of the hearing that she would be sending subpoenas to the witnesses for documents and communications about their roles in misleading the public and policymakers. The committee plans a series of follow-up hearings next year, and which they hope will uncover even more evidence of the fossil fuel companies' current and past deception. So with that, I think I'm going to ask my fellow panelists to come back and undo their, turn their videos back on. So we can do some Q&A. So I'm going to start out and ask folks particular questions coming from your presentations, but I encourage others, if you have more to say on the same topic, please just unmute yourself and jump in. So Alyssa, I'm going to start with you. So you really laid out a very, very compelling case. What has been the industry's response to the lawsuits and to the claims that they've been lying and deceiving to the public?
There have been a number of responses, both in and outside of the courtroom. I would say that, as an initial response, I think the companies and their front groups, thinking of the Manufacturers Accountability Project in particular, often come out with statements anytime lawsuits are filed or briefs are filed to make the argument that these lawsuits are frivolous and that they don't advance meaningful climate solutions. And that's been a party line from the industry and their front groups. In the courtrooms and in the legal arguments that they present, I think the defendants really mischaracterize the cases, and I'm sure Vic can speak to this as well. But they claim that these cases are really an attempt to regulate emissions, which was, along the lines of the first wave of climate liability lawsuits that he mentioned, and an end run around Congress. And rather than what they really are, which is an attempt to hold bad actors responsible and accountable for their deceptive actions. They also make these arguments about shifting responsibility from themselves as polluters to individual consumers. They're saying that the responsibility for the harms associated with their products falls on the users, not on themselves as the producers. So I think that's a really important argument that we saw put forward by the tobacco industry. We've seen it from other industries, and the fossil fuel industry is certainly advancing that argument. One really good example is BP and the carbon footprint. That was something that they created to really put the onus and shift responsibility onto individual consumers. I would say that, there have been a number of legal counterattacks, and I might punt to Vic to address that question, whether that happens now or later. But I know that that was an issue that you wanted to raise as well.
Pamela, would you like me to talk about that a bit now?
Sure, absolutely.
So in the courtroom, we've seen basically three sorts of legal counterattacks. One is in Massachusetts and New York states initiated investigations, and in response against Exxon, investigating Exxon's role. This was a number of years ago, and in response, Exxon filed a lawsuit in federal court in Texas claiming that these were impingements on their First Amendment rights. The case was ultimately transferred to the Southern District of New York. The district court judge there issued a scathing opinion saying that there was no First Amendment implications to an attorney general investigating potential consumer fraud and deceptive behavior. And throughout the lawsuit, and that issue is still pending up on appeal in the Second Circuit now. In response to a number of the California lawsuits that were filed in California, Exxon filed in Texas state court, Tarrant County, a pre-complaint petition for leave to take discovery. And their theory is that the lawsuits filed in California are part of an improper conspiracy to deprive Exxon of its First Amendment rights in Texas, and therefore to harm the state of Texas itself. And the trial court judge denied so in that proceeding, it's a potential defendant, but it's the plaintiffs in the California cases, denied the motion to throw the Exxon's petition out for lack of personal jurisdiction. That went up to the Intermediate Texas Court of Appeals, which reversed and held that there was no jurisdiction, but they sort of held their nose doing that. And one of the concurring justices asked the Texas Supreme Court to weigh in and change the law of personal jurisdiction in Texas. Exxon has now petitioned the Texas State Supreme Court, and we're waiting to see whether they're going to take the case. And then in the courtroom, we've seen Exxon and Chevron in particular assert as part of their motion practice that the lawsuits brought by Massachusetts and in Honolulu by the city and county of Honolulu, that those lawsuits themselves are strategic lawsuits against public participation, and they have invoked what's called the anti-SLAPP laws. The trial court judge in Massachusetts denied the motion, and that case is proceeding. And in Honolulu, the motion has been argued. The interesting twist in Honolulu is that Hawaii anti-SLAPP law clearly didn't apply because it only applied to statements made actually in legislative proceedings. And so Chevron's theory was that the lawsuit by Honolulu violated California's anti-SLAPP suit in Hawaii. And that motion's been argued, and we're waiting Judge Crabtree's ruling.
Wow, they're relentless, right? They are relentless. So Karen, if you could jump in to talk a little bit about some of the implications for these kinds of defensive maneuverings by the industry.
Talking very broadly, because they're throwing everything at it in terms of defensive moves possible. What I see is the key theory that they're relying on, stated very broadly, because it's based on a very questionable interpretation of very old Supreme Court cases. Mm-hmm. But taken to its logical conclusion, its defense is basically that anything related to climate has no place in courts, state or federal. So the first step is getting it removed, but ultimately that's where they think it can get dismissed. And it's basically by saying anything related to climate is for the policymakers to address, if at all, and it has no place in state courts, which is pretty astounding because courts would be increasingly irrelevant in our current reality because courts deal with facts, and climate disruption is a fact, and the industry's disinformation campaign, as Alyssa laid out, is a fact. So that's for courts. That's for courts. It's for policymakers too, in a different role. But the notion that anything broadly relates to climate is quite dangerous in our current reality. That doesn't belong, or would be quite dangerous in our current reality because we essentially have no meaningful judicial branch. And so I think this argument is dangerous on a number of levels.
Yeah, and I would just add that I see it on Capitol Hill, right? So they come to Capitol Hill and they say the same thing, is that you need to get rid of these lawsuits because this is your role, Congress. This is your role to address climate change, in which we know, and I tried to lay out in my comments, it's not the role of Congress, right? To assess liability or responsibility and assess damages. That's totally not the role of Congress, but they, conflate them. And then of course, the same time, the same industries and the same companies are lobbying against any meaningful climate change legislation.
Right.
So
Right. It's really problematic, and they're lobbying against, of course, at the international levels as well. I mean, in actions in all spheres, they're just whatever sphere they're currently in. They're like, it's in that other policymaker's ball, it's in their court, and nobody's dealing with it. Yeah.
Right, precisely. So, so we've been talking about this state versus federal court question. So, Karen, I'll go back to you, but again, folks should jump in. So what would happen, do you think, if we got a Supreme Court ruling, for example, that these cases belong in federal court instead of state court?
So related to my description of states' role in our constitutional system, I think it's important to realize that such a ruling would be a tremendous expansion of federal judicial authority in an area in which the court has heretofore expressed great reluctance to tread, because public health and safety is an area of what the court calls traditional state concern, and recognition of the vital role that states provide in that regard. And that preservation of state authority in this area is important to our federal system of governance that divides power between national and state and local authority. So in terms of what the Supreme Court would do it a bit more detail by expanding its judicial authority, it would essentially upend essential longstanding procedural rules that have been in place to, in a sense, police this line, and allowing for states to have enough room, and state courts in particular, to not be improperly removed. And finally, the implications would be to reward the defendants' really egregious mischaracterization of the state claims in order to get these into federal court. I mean, it really does not take after your first year of law school, you could evaluate that and determine that that's a gross that's not the same claim. And so to reward that just would call into question the integrity of the court as well, I believe.
Vic, do you have anything to add as you're in court litigating these?
Well, just that the aspect of the cases which, as Karen has described, are inherently state law-based torts that are backward-looking, not policy matters, and that don't involve regulation of emissions, but rather just bad and deceptive corporate behavior. To make those federal issues that support removal jurisdiction would essentially make any business tort against a multi-state or multinational corporation a federal question. And the Ninth Circuit is the circuit that so far has actually addressed the jurisdictional issue of whether there's a federal question involved in these cases on the merits. And Judge Ikuda, a Bush II appointee who's a conservative and intellectually rigorous and honest jurist, I believe, looked at the complaint, looked at the issues, and simply said, no, there's no federal question that would support federal court jurisdiction here. And I think that's why we have seen a 13-0 record in the district courts and a 5-0, 6-0 record in the courts of appeals to date.
So I want to switch gears just a little bit to go back to Alyssa to talk about kind of the modern day denial, because you pointed out in your presentation that what the companies are saying has changed over time. But if you could talk a little bit more about how it has changed.
As you mentioned, the manner in which they are communicating about climate change is fundamentally different. I think there is a clear acknowledgement by the fossil fuel industry that climate change is real. It's caused by their products, that there is a need to take climate action. And they are now actively promoting themselves as I mentioned before, good faith partners, part of the solution. They want to engage in dialogue and negotiations wherever those are taking place. I think the role that they play in each of those negotiations is questionable. But the fact is that they are spending an incredible amount of money to promote themselves as these good faith actors and to position themselves as part of the transition to a clean energy economy, when that's not in fact the case. It really is all talk, no action. Their actual investments in renewables and low carbon technologies are, as I mentioned previously, quite low. Less than 1% of total global investments in low carbon tech came from the fossil fuel industry. So you can see that the money is coming in, and there are financial flows to support renewables and low tech or low carbon technologies, but it's not coming from the industry itself. I'd also like to mention, and I didn't mention this in my initial presentation, but there are a number of commitments or quote unquote pledges that are being made by a number of these companies. BP, Shell, Chevron have all made net zero commitments, but there are a number of loopholes in each that need to be looked at quite carefully. I can tell you that in BP's net zero goal, they've excluded an estimated 46% of its emissions from its total net zero goal. So that raises a question of what are we talking about here? A number of other companies have excluded certain types of emissions. So they include scope 1 and scope 2 emissions, but not scope 3. And I can tell you that in each and every one of these commitments or, again, pledges that are being made, they rely heavily on unproven technologies, and in particular, CCS, carbon capture and sequestration, which is an unproven technology that has not yet been brought to scale. And recent research indicates that it could emit more than it captures. So we just don't know how this is going to work or how they're going to meet these, net zero goals and what they will look like. So I think it's safe to say that their commitments are completely inadequate and oftentimes, disingenuous in what they're trying to achieve. Some of these companies have said that they would, align themselves with the 1.5 degree goal set forth in the Paris Agreement, but they're not even close to achieving that. So I think there's a far way for them to go in order to make a legitimate claim that they are good faith partners.
Right, and I'll just tell you from watching the CEOs during the recent House hearing, their their responses were very, very orchestrated, I would say, and very carefully lawyered. And so, because when they are up there testifying before Congress, they are under oath and they cannot lie. And so they were pushed to try to, by the members of Congress to sort of make some of the claims that you're talking about, Alyssa, or respond to them. And they stayed far away from really saying anything concrete as a pledge or a promise. And they also were very fuzzy about their own products' contributions to climate change. And so while they were willing to admit it, they were willing to admit it in a very sort of weak way, because again, they know that they're the CEO of the company and their statements can be used in other contexts. And so I found it to be very interesting, and it led to great frustrations, as you can imagine, by the members of Congress on the panel who wanted some real answers. They weren't getting much. So anybody else have anything to add on that?
Well, just to clarify, Alyssa used the term scope 3 emissions, and the exclusion of those is particularly startling because scope 3 emissions are the emissions that result from the combustion by the end user. So if you exclude scope 3 emissions, it's like the old Werner von Braun quote, I make them go up, who knows where they come down. That's not my department, said Werner von Braun. It's you launch the products into commerce, but you don't count the emissions associated with their end use if you exclude scope 3. It's nonsense.
Right, absolutely. So I wanted Vic to also go back to you and just ask you about the relationship between the court actions that you're involved in and the court of public opinion and the whole debate on climate change.
Well, I think the link is between really what Alyssa was talking about and some of what you've been talking about, Pam. There is a concerted effort to portray in the media the lawsuits as having an improper motive, and the lawyers involved, both public counsel and outside counsel, as having improper motives. And in particular, Alyssa mentioned the National Association of Manufacturers and their project called the Manufacturers Accountability Project, which is very well funded and very sophisticated, and whose, if you go to their website, their avowed purpose is to attack the lawsuits and the lawyers and the parties that are involved. So all of that is, I believe, laying groundwork for an effort to achieve immunity in Congress, because that's what they need, frankly.
Yep, and we have seen it already. I think, ironically, one of the reasons that we are not seeing a huge overt push right now is it's going to go along with some meaningful climate legislation, right, that Congress would pass, and then that's going to be their response. Okay, we're going to regulate here. That's Congress's role. The courts don't have a role to play here. We need to get rid of those court cases. They're just bogging us down, distracting us from the business at hand of addressing climate change. And so that's where it goes hand in hand. And that's what we saw with the Climate Leadership Council, right? They said we're for carbon pricing. We're not for regulation, though, and we're also not for the lawsuits. So the fact that climate change legislation, other than budgetary funding for climate investments, but real regulatory legislation is probably not in the cards for a little while. They're holding their fire a little bit about preemption, but I'm certain that it's going to come back in a big way, and they're already making the case for sure. Alyssa, just to go back to you about the, there is the investigation that's going on in Congress, now. I don't know if you have thoughts about whether we think that there's going to be something meaningful coming out of those investigations that maybe we haven't seen from the from the companies yet, or more information about what we have seen.
I certainly think that Chairman Maloney and Khanna are 100% committed to moving this investigation along, to ensuring that the subpoenas are responded to properly. The subpoenas that they issued, I believe it was within days after that hearing back in October. So there is a clear commitment and intent to follow through. And I think the idea here is really to gather more information from these fossil fuel industry executives about what they have known about climate change and how they're actively responding to proposals for climate policy at this stage, and what influence they're trying to have here. And also trying to better understand, the company's funding of third-party front groups, which they claim, they openly stated that they don't fund disinformation, but we know that's not the case. And I think that, Chairman Maloney is really trying to get to the bottom of this, and to better understand, to also better understand the plans to reduce emissions, and whether or not these are legitimate good faith efforts. So I think that this is something that we can, certainly watch and track going forward. My expectation is that we will see more hearings in the spring. You may have more intel about that, Pam. So I'd love to hear your thoughts as well.
Sure. Yep. I think that they are planning follow-up hearings, and I think they're planning to put a staff report together at the end of the process that will incorporate, hopefully, the information that they get from the companies. The committee did send a series of letters to the companies asking for information prior to the hearing, and really received very little beyond literally printouts of their websites or brochures, or very non-responsive. And then, as I said, they were similarly non-responsive during the course of the hearing. There was a lot of good information that came out, but it came out because of the work that the members of Congress themselves had done, but was not forthcoming from the CEOs. And so we hope now with the subpoenas, as you say, that we're going to get maybe more and new information from them. But it was, the video of the Exxon lobbyist that was done in an undercover way, and that came out, gave us a little slice, right, of what they actually talk about behind closed doors. And maybe we'll get a little bit more than that. I believe he has been fired, but we'll get maybe some from some others. So I think we're coming to the end of our time. Does anybody have closing comments they want to make before we say goodbye? Okay. Well, I will do that, and thank you so much. And I really think that, as I said, I learned a lot, and I hope that the audience has learned. This is horrifying to learn about and to actually hear the facts, and yet, I feel better knowing that these cases are being brought and they're being litigated in our courts right now, and seem to be doing well. And I think that we can learn a lot about what the companies have done, what they are doing, that is going to help us avoid this same kind of problem in the future from companies that are doing such harm to people and to the planet. And to get some relief for these communities that will really inform everybody's work to address these problems going forward. So we're grateful to the Tort Museum for hosting this, and also for reminding the public every day the importance of tort law and access to the civil court system that can give us so many benefits, and where the little guy can go against the big guy and actually win. And I think with that, we'll say goodbye and thank you.